Hello again, Stephen D here, or Steve Strauss if you'd prefer. Today we're talking about Mr. Mueller's indictment of those 12 Russian alleged intelligence operatives. I'm not going to be talking about the specifics of the indictment. Other people have done that. I'll leave some links to some of the articles that discuss the issues they have with the facts mentioned in the indictment. What my purpose is today is simply to explain to people what an indictment is, when it's done through a grand jury process, and what it isn't. Now, a lot of people have been on the social media and in mainstream media essentially saying that this indictment proves that Russia interfered with our election. Actually, it doesn't prove a thing, and I want to explain to you why. Alright, so there's two ways that a prosecutor can obtain an indictment against individual or individuals they believe committed crimes. One of those is what's called a preliminary hearing. A preliminary hearing is open to the public. It's before a judge, and the defense attorney for the person who is being accused of the crime is allowed to be present and to cross-examine any witnesses that the prosecution calls. Now, it has the same level of burden of proof. In other words, to obtain an indictment, all you need to show, or all the prosecutor needs to show, is that he has sufficient evidence that, probable cause that a crime was committed and that the person that is the focus of the indictment was responsible. Probable cause is simply, more than 50%. Alright? It's a very low bar. Prosecutors, whether they're involved in preliminary indictments or in grand jury indictments, do not have to present all their evidence that they have. But there's a big difference between the two. In a preliminary hearing, a judge is hearing the evidence, and so it's got to be evidence that meets the standard of the rules of evidence. In other words, there's some things that, like hearsay, for example, is probably the one that's most formally, what most people know about. Hearsay is not acceptable as evidence. So anybody who, prosecutor can't use that in a preliminary hearing. This is different, however, from what a grand jury does. Grand jury proceedings are secret. There is no judge involved. People who are called to, testify before a grand jury are not allowed to have their lawyer present. Okay? It's all up to the prosecutor. The prosecutor doesn't have to provide any information or provide any documentation or evidence that contradicts his theory of the case. All right? By theory of the case, I mean the idea that simply this is a person who committed a crime, and here are the reasons. In other words, he only has to present evidence or alleged evidence that, whether through witnesses or documents or whatever, that is sufficient to convince, majority of the grand jury members, because you don't need a majority. You don't need, you don't need unanimity. You don't need a unanimous vote like you do in a actual criminal trial to convict somebody. To indict somebody, all you need to have is a majority, and it depends on the jurisdiction, but the majority of the grand jurors Grand juries also only meet when the prosecutor has evidence to present to them. They can go on for months and months. They can look at anything the prosecutor brings, whether it would be admissible in evidence or not. So there's all sorts of, you could have any witness come in that you wish, and say anything, and there's nobody to cross-examine the witness to deal with, the credibility of what the witness is saying. Now, so what an indictment does is that prosecutor's been able to, by manipulating what he shows the grand jury members, he's been able to convince a majority of them that a crime was committed, more likely than not, that there's probable cause to believe that this crime was committed by a particular individual or a group of individuals. It's not proof. It doesn't even approach the standard of proof. There's stuff that comes out at trial, like that is exculpatory. In other words, that would tend to show that the prosecution's evidence is weak, or that there's evidence that shows that the defendants, in fact, that contradicts that evidence, or tends to diminish the credibility of the witnesses the prosecution calls. None of that is presented at a grand jury, unless the purpose of the grand jury is specifically to make sure that their indictment is not voted on, as we saw in the case in Missouri, when there was a grand jury regarding Michael Brown, and they actually rigged it so that they brought in witnesses to specifically discredit those who claim that the police officer in that case was at fault. And even the police officer come in and testify, which is something you would normally not do. You would normally not call in the person who's suspected of a crime and have them testify without their attorney there, unless you're trying to not obtain a grand jury indictment. So this goes to show that the prosecutors have a great deal of discretion as to what they present. Now, in this case, we know that no federal agency looked at the DNC server in question. No one. So it's all based on evidence, or claims made by a security company known as CrowdStrike. CrowdStrike was hired by the DNC in May, and it's hired by the attorneys for the DNC, who are also the attorneys for the Hillary Clinton campaign. And it's important to remember at this time the DNC was also effectively controlled by Hillary Clinton pursuant to the contract they entered into with her in September of 2015. So we know that the FBI never looked at this computer, these servers. We know that everything in this indictment has to be based on whatever this company CrowdStrike said. And there's a number of things that the indictment doesn't mention. Specifically the fact that Julian Assange specifically stated 2 days before CrowdStrike, or before the Goosefer 2.0 entity appeared, said he had documents regarding the Clinton campaign that included emails. So, they leave that out of the indictment, because the indictment doesn't. You don't have to present that kind of evidence. You don't have to present anything that would cast doubt on your case. All you have to do is present anything and everything you can think of that supports your case, whether it's something that's you can put into evidence and get admitted into evidence or not. But more importantly, you don't have to put in things that discredit your case or would cause a grand jury to possibly consider that maybe this is a weak case, maybe it's not more likely than not that this is what happened. Maybe we're being sold a bill of goods. So there's a big difference between a grand jury indictment, and actual proof of the crime committed, in this case, hacking into the DNC's computers allegedly by these Russian intelligence agents. There's one more thing I wanted to bring up about grand juries, which is also different. You can, as a prosecutor, get rid of a grand juror based on cause. And what's cause? Well, cause is basically anything that the prosecutor can come up with that would show potential bias. So, for example, one of the questions they would ask the grand jury would be, or a potential grand juror would be that, for example, did you vote for Trump? Do you believe Trump committed, crimes or collusion with the Russians? Are you a Trump supporter? And so any of those people are immediately wiped, would be immediately excluded for cause. Anybody who'd ever had any business dealings with Trump or with anybody he's ever been associated with, that would also be cause to exclude those people. So you begin to narrow down the grand jury, okay, until it's a group of folks inclined to, at least hear you out and don't have any preformed ideas or anything at all regarding the case. In fact, you would not. In fact, you would most likely want to have all people who supported Hillary Clinton in your grand jury. Now, has that been done in the Mueller case? I don't know, but it's certainly a possibility with the way the grand jury system operates. It's also a possibility that the grand jury decision was not unanimous. You can have up to, I believe, 23, maybe 24 grand jurors. So, all you need is to have a majority of them. I believe under federal rules, 12 jurors out of all the grand jurors. So, it's not proof. All it is it's an instance where the prosecution has laid out to a group of people in a secret, hearing run by the prosecution without any judge present, without any defense attorneys present. All those bits of evidence, whether they're documents, whether they're computer logs, whether they're testimony by experts, or testimony by the people from CrowdStrike, because we know the FBI people couldn't have talked about it. They never saw the DNC server. No government official has ever examined that DNC server. In fact, I don't believe it. If I'm correct, I don't believe it no longer exists. It was long ago wiped and taken, out of commission and disappeared. So there's no way that we can ever see, prove out other than believing what the CrowdStrike people tell us they found. And of course, you can rest assured that Mr. Mueller did not present any evidence that would attack the credibility of those CrowdStrike witnesses who testified at who gave testimony at the grand jury proceeding involving these alleged hackers. So I just wanted to make that clear. This, just from a standpoint of, is an indictment proof? No, it's not. It's not proof. It's not sufficient to convict anyone. And, it's also interesting that, of course, he's indicting people that we don't have an extradition treaty with. So there's no way, for example, that we'll know probably ever what the evidence was that was presented to the grand jury, unless it's released as unless it's released pursuant to some sort of report that Mueller ultimately presents, which I suspect will be classified documents, so we'll only see the unclassified portions of it. Because I have, from just reading the indictment, it's pretty clear that some U.S. intelligence assets or whatever were involved, whether they were human or other types of, U.S. intel through the NSA or somebody. So just keep that in mind, that an indictment, it does not prove anything. All it does is it's a group of people handpicked by the prosecutor who presents, the best evidence he's got and excludes anything that might cause people to doubt his version of or his narrative of the case. All right. So, for those of you who'd like to get into more about the issues surrounding the credibility of the allegations made, I'll leave some links below to folks who have done that. But sole purpose of my video is simply to indicate to you that no, an indictment doesn't prove anything. A lot of people have been indicted and nothing happened. In fact, we're seeing that right now in the earlier Mueller indictment, where one party finally, one party showed up in court, accepted service of the complaint, and the Mueller team immediately went into panic mode and decided, whoa, first they tried to get the lawyers for this individual dismissed. Then they tried to, say, the judge overruled. And then they tried to get discovery, of their evidence prevented. The evidence they claim they had that showed that these people, purpose was to influence and commit crimes and etc. So we already know Mueller or his team have no desire really to take any of these things to trial, and by the fact that they did not name any U.S. citizens as or anybody within the jurisdiction of the United States as one of the defendants indicted, indicates that they really don't want this case to go to trial. Other things I can mention is the fact that they ignored the offer that Julian Assange made last year, that he'd be willing to talk and testify and give a deposition to Mueller regarding what WikiLeaks knew about these matters. I mean, he just ignored that. Never spoke to Assange. You'd think, since Assange and WikiLeaks is a critical part of the indictment, they're named several times as under a pseudonym, but they're named several times in the indictment. It's pretty clear that who they're talking about, even though they don't say WikiLeaks by name. You'd think that as part of that investigation, if it was truly a diligent, honest investigation, they would have accepted agreeing to meet and speak and take the deposition of Julian Assange and or anyone else involved in WikiLeaks. But they chose not to do that. So, what do we know about this indictment? We know it's not proof of Russian interference. We know it doesn't show that there's any collusion, because it, specifically states it doesn't with the Trump campaign. So, what's the purpose for it? Well, I'll let you decide. But the important thing to remember, first and foremost, is that an indictment is not proof of guilt of anybody. It's not proof that it's accurate. And there have been a number of indictments of people that were innocent and wrongfully brought to trial. So, with that said, I will say goodbye for now. Check the links below to those other articles that I indicated that cast doubt on the claims made in the indictment. Stephen D. signing off for now. Thanks for listening. Take care. Bye.